it when you're talking. Yeah, just
Call the subcommittee to order. I welcome all of you here today. Congress designs our immigration policy to benefit the American people. When immigrants receive visas or citizenship that they're not entitled to, Americans are worse off, whether it's workers, taxpayers, or simply citizens. If there's a credible allegation that this is occurring, we have a duty to determine the truth. Such allegations were made by a January 2012 Department of Homeland Security Office of Inspector General report. The report was entitled "The Effects of USCIS Adjudication Procedures and Policies on Fraud Detection by Immigration Service Officers." The Inspector General found that U.S. Citizenship and Immigration Services adjudicators are not receiving adequate training to uncover fraud in immigration benefit applications. The IG found that USCIS performance measures favor quantity over quality. This encourages the rubber stamping of applications. The IG found that the adjudicators feel inappropriately pressured by supervisors and USCIS leadership to approve petitions that don't meet the standards for approval. USCIS leadership seems to favor get it to yes instead of get it right. It's important that the adjudicators make their decision in a timely manner. Yes, but it's also important that they have adequate time and support to ensure that the individuals who receive immigration benefits, such as a temporary visa, permanent residency, or citizenship, are in fact eligible for those benefits. Immigration benefit denial rates obtained from USCIS show a rise in denials in certain categories between the years of 2008 and 2010. Some will argue that this shows that there is no improper pressure on adjudicators. However, the rise in denials may simply be a result of adjudicators following the law, and the increased pressure by USCIS leaderships to approve applications may be an attempt to reverse this recent trend. I know that many in this business community are concerned that their petitions for alien workers are being denied and they are being required to answer excessive requests for additional evidence known as RFEs. But why did denial and free rates go up? And it very well could be because of statutory changes that were implemented and major decisions that were issued. For instance, the changes made by the L1 Visa Reform Act of 2004 to prevent contracting out of alien workers were not implemented by the agency-wide level until 2008. As one would expect, there was a corresponding rise in USCIS denial rates in fiscal year 2008. And the 2010 Newfield memo on H-1B visas issued by the USCIS Associate Director for Service Center Operations provided new guidance on what should be considered by employer-employee relationships between the petitioning company and the beneficiary. After that, the Government Accounting Office noted companies' petitions were no longer being approved at previous rates, and the GST decision was issued by the USCIS Administrative Appeals Office in July 2008. It provided a new framework for adjudicators when determining whether or not a petition meets certain L1B visa requirements. Both those who support and oppose this AAO ruling can agree that it has had the natural result of increasing subsequent denial rates in the L1 category. But whatever may be the cause of the denial rates in a particular visa category for a particular year, USCIS's own data shows that the overall denial rate for non-immigrant worker visas has fallen over 30% since President Obama took office in 2009, and that the approval rate for all immigrant benefits is at an all-time high of 91%. There is never a legitimate reason to pressure adjudicators to deny petitions where the beneficiary is eligible for the benefit. And there is never a legitimate reason to pressure adjudicators to approve petitions that do not meet the statutory requirements. But according to the Inspector General, some USCIS adjudicators feel such pressure. That's why we're here today. We will receive testimony from the DHS Inspector General, who will explain his January 2012 report findings. We will receive testimony from the President of the National Citizen and Immigration Services Council, which represents USCIS adjudicators. We will discuss how performance standards that emphasize quantity over quality imperil the integrity of the adjudicator's process. And we will hear from the USCIS Director Mayorkas, who will help determine whether or not there is a get to yes mentality at the USCIS. And with that, I would yield to my good friend, the ranking member from my home state, California, the gentlelady, Ms. Lofgren.
Thank you, Mr. Chairman. There is an old parable about blind men and an elephant. One blind man feels the elephant's leg, thinks it's a column. Another feels its tail, thinks it's a rope. Another feels the trunk and says it's a tree branch. Having felt only one part of the elephant, each blind man is in total disagreement with the other about what they're touching. And in some ways, although I have great respect for the Inspector General and the mission of the IG to prevent and detect waste, fraud, and abuse in government operations. That's kind of what we ended up with in this report. The IG system is really important. I'm a big fan of the IG system. It's essential to get facts for members of Congress so we can be guided in our policy making for an effective and efficient government. But a report that reminds me of the blind men with the elephant is not what we need, and I'm afraid it's what we got in this case. When I first received the OIG report, I did what I always do. I turned to the methodology page because a report is meaningless if its methodology is not sound. Are its surveys fairly worded and statistically valid? Does it include objective analysis of hard data? On these questions, I believe the report comes up short. The report does not review available statistical data. The OIG did not apparently seek input from outside stakeholders. It does not look like they talked to other government components critical to an understanding of USCIS, such as the Ombudsman's Office. Instead, the report is based almost entirely on 147 interviews and 256 self-selected responses to an online survey, representing just over 2% of the 18,000 people who work at the USCIS. In general, reports can be useful if the questions are useful, but the responses have to be not self-selected for bias. And what we have here, I'm afraid, is a self-selected group of people who have a complaint. Their complaints may be valid, but they're certainly not representative. For example, the report finds that there may be undue pressure on adjudicators based on the responses to the following question. Here's the question in the report. Have you personally ever been asked by management or a supervisor to ignore established policy or pressured to approve applications that should have been denied based on fraud or ineligibility concerns? Importantly, 75% of those who chose to respond said no, but 63 individuals said yes. That's out of 18,000 people who work for the USCIS. But that doesn't tell us very much about this response. We don't know when they felt this pressure. Was it 6 months ago? Was it during the Reagan administration? We have no idea from this report. And we don't know whether it happened once or whether it was repeatedly. And we don't know what the pressure actually was. Was it a simple request to have the adjudicator look again at the facts of the case or something improper? There's no way to tell from the report. Yet based on this slim read, the report paints a picture of an agency in which almost every facet is tilted towards the approval of applications and petitions. Based on the interviews and survey responses, the report endorses the proposition that USCIS suffers from a culture of getting to yes. Now, this would be concerning if it weren't so surprising, because for the last several years, I've repeatedly heard from interest groups, constituencies, the Chamber of Commerce, the business community, that the agency is actually suffering from the reverse problem, that they are saying no to cases that should be approved. American businesses in my district and elsewhere say that the agency has become more stringent, that the increase in denials and delays are unreasonable, that petitions that used to be approved quickly are now denied or slowed by lengthy requests for evidence. And they've shared some cases indicating that adjudicators may have altered long-established requirements or tightened standards without notice to stakeholders or the Congress. They share examples of requests for evidence that really boggle the mind, such as asking, and I saw this, a well-established Fortune 500 company that employs thousands of people to provide leases and floor plans and fire escape routes to prove that they actually exist. When I first saw the report, I asked my staff to request and review data for all the adjudications in the last decade. And I understand that upon receiving the report, the majority made the same request. This data, which unbelievably was not analyzed by the OIG, shows a sizable increase in denial rates for key businesses' visas categories and appears to support what I've been hearing from businesses for the last several years. In some categories, the denial and RFE rates have increased by 300 to 500% during the Obama administration. Now, I can't tell, and I'm not claiming whether what the right approval rate should be. You know, maybe it's too low now, maybe it's too high now. You can't tell from the report whether this is higher quality or adherence to law or whether it's more mistakes. And certainly the OIG report gives us no guidance on that. I would take issue with some of the report's recommendations as well. To end an informal appeals process and, quote, special review of denied cases is such a mistake. I can't believe the OIG would have made this recommendation if they had engaged with stakeholders and reviewed some of the actual cases. And let me just give you a couple of examples. I mean, perhaps with one or two exceptions, virtually every member of Congress has contacted the USCIS to ask for review of cases that were erroneously denied. And certainly I am among them. For example, I had a recent case in which the USCIS denied an employment-based petition because the adjudicator determined that the company only had $15,000 in annual revenue and therefore couldn't possibly pay the worker. It turned out, however, that the adjudicator had failed to note that the figures were listed in thousands. It was actually $15 million in revenue. So the OIG's recommendation for a formal appeal process would have required a 2-year process just to point out that the person in the bureaucracy misread the file. Surely that couldn't be a wise response. I had another case in which an H-1B worker with an approved employment-based green card petition had his application for adjustment denied because he did not provide evidence establishing eligibility for the Cuban Adjustment Act. Well, the applicant wasn't Cuban, and he wasn't applying under the Cuban Adjustment Act. He was applying under a different provision of the law. Under the proposal, this individual with an approved petition would have had to go back to his country in Europe for 2 years because the employee screwed up. How could that be a reasonable response to somebody making a mistake in the bureaucracy? I think finally, in light of the committee chairman's op-ed in the Politico today entitled "Obama's Lax Visa Policy Imperils U.S., I do believe one part of this report needs to be emphasized. And here is a direct quote from the report. No ISOs, that's Immigration Service Officers, presented us with cases where benefits were granted to those who pose terrorist or national security threats to the United States. Even those employees who criticized management expressed confidence that USCIS would never compromise national security on a given case. I yield back, Mr. Chairman.
The gentleman from Texas, the chairman of the full committee, Mr. Smith.
Thank you, Mr. Chairman. The vast majority of those who apply for immigration benefits have no ill intent toward the U.S. They come here for legitimate work or travel. But American immigration benefits, whether they are in the form of H-1B visas, permanent residence for relatives of U.S. citizens, employment authorization documents, or naturalization, are of great value around the world. For that reason, there are foreign nationals who will do and say whatever they think will get their benefits approved, forge documents, get bogus employers to sponsor them, and even deny their terrorist ties. So we must have policies in place that help ensure we will not admit those who intend to cause us harm or make a mockery of our immigration system. We need immigration policy designed to protect American workers and taxpayers. Officers at U.S. Citizenship and Immigration Services are the first line of defense against those trying to come into the United States by fraudulent means. In 2002, the then General Accounting Office found that immigration benefit fraud was pervasive, on the increase, and rampant at the Immigration and Naturalization Service. And in 2006, the now Government Accountability Office again found that, quote, although the full extent of benefit fraud is not known, available evidence suggests that it is an ongoing and serious problem, end quote. GAO reported that the immigration officers interviewed felt management didn't emphasize fraud control, but instead focused on production goals designed to reduce the backlog of applications almost exclusively. Also in 2006, the Department of Homeland Security Office of Inspector General reported on a lack of incentives for USCIS personnel to combat fraud, as opposed to simply rubber stamping applications to get gold stars for improved productivity. The allegations of rubber stamping continued, and whistleblowers began providing details to congressional investigators. In October 2010, Senator Chuck Grassley asked the DHS Inspector General to again look into whether, quote, senior U.S. citizenship and immigration service leaders are putting pressure on employees to approve more visa applications, even if the applications might be fraudulent or the applicant is ineligible, end quote. Last month, the Inspector General released a report detailing findings based on Senator Grassley's request. Specifically, the IG reported that the mindset of quantity over quality has not ended at USCIS. In fact, according to the report, nearly 25% of Immigration Service officers who responded to the IG survey have been pressured to approve questionable applications. This mindset is called get to yes regardless of the consequences. Where does it come from? Rogue supervisors or from the very top of USCIS? Such pressure undermines the rule of law, the integrity of U.S. immigration policy, and national security. This rubber stamp process leaves an ink trail of fraud and abuse. For instance, in 2005, the Office of Fraud Detection and National Security, FDNS at USCIS, reported a 33% fraud rate in the religious worker visa program. Following that disturbing find in 2008, USCIS issued a rule designed to strengthen the requirements for religious worker visa processing. The rule included a site visit requirement. And last December, FDNS issued a follow-up report noting a fraud rate of less than 6% in the program. And in 2008, FDNS found a 21% fraud rate in H-1B cases. The FDNS report triggered site visits to H-1B employers, which resulted in nearly 1,200 adverse actions by USCIS and the prosecution of 27 people. As long as FDNS is allowed to operate in an unhindered fashion, it is an asset to USCIS and to all Americans. USCIS processes more than 6 million immigration benefits applications or petitions each year. That is no small job, and security should be the #1 priority in that process. At the same time, legitimate petitions should be approved in a timely manner. I look forward to the witnesses' testimony so we can be assured that security is, in fact, the top priority at USCIS. Thank you, Mr. Chairman. I want to say also that I'm going to need to go to another committee hearing momentarily, but I'll return, I hope, in a few minutes for questions. Thank you. Yield back.
Thank the gentleman. We have a very distinguished panel of witnesses on our first panel today, and I would just ask that you help us all by trying to keep your opening statement limited to the 5 minutes, but your statements will be made of a part of a record of the hearing and in its entirety. And so with that, let me introduce our two distinguished witnesses. First is Director Alejandro Mayorkas. Director Mayorkas has served as the Director of the U.S. Citizenship and Immigration Services since 2009. Prior to his appointment, Director Mayorkas was a partner in the law firm of Michael Obelvaney and Myers, and before he served as the U.S. Attorney for the Central District of California. Director Mayorkas is a graduate of the University of California at Berkeley and holds a J.D. from Loyola Law School. Our second witness is Mr. Charles Edwards. Mr. Edwards is Acting Inspector General of the U.S. Department of Homeland Security. Prior to this position, Mr. Edwards served as a Deputy Inspector General of the Department of Homeland Security and held leadership positions at several federal agencies. Mr. Edwards is a graduate of Loyola College in Maryland and has a double master's degree in electrical engineering and computer engineering. So with that, we will open the hearing to Director Mayorkas. Welcome.
Thank you, Chairman. Chairman Gallagher, Ranking Member Lofgren, members of the subcommittee, thank you for the opportunity to testify before you about the efforts of U.S. Citizenship and Immigration Services to protect the integrity of our nation's immigration system and to help safeguard our nation's security. I appreciate the committee's interest in learning about our continued prioritization of the agency's efforts, which are unprecedented in their scope and effect. I want to take this opportunity to thank the men and women of USCIS whose dedication to the agency's mission is unwavering and whose hard work makes our vital mission a reality. Together as an agency, we are committed to administering our nation's immigration laws efficiently and with fairness, honesty, and integrity. I also want to thank the U.S. Department of Homeland Security's Office of Inspector General for its role in reviewing our efforts. The OIG's independent review of our agency's operations assists us in our pursuit to improve each and every day, including in the priority areas of combating fraud and strengthening national security. I came to this country as a refugee, escaping the communist takeover of Cuba. My father and mother instilled in me a profound and abiding appreciation of and respect for the rights and responsibilities that define my United States citizenship and the rule of law that is its foundation. It was the values my parents instilled in me that led me to become an assistant United States attorney, specializing in the investigation and prosecution of criminal fraud. From my nearly 12 years as a federal prosecutor, culminating in my service as the United States Attorney for the Central District of California, I learned what it means to enforce the law and to do so in furtherance of our national security and public safety. Historically, our agency has been challenged by a culture that focused primarily upon making adjudication decisions quickly, resulting in a significant and ongoing tension between the quality of our adjudications and the speed with which they are made. This tension, in an agency that processes approximately 7 million applications and petitions annually, has existed for many years. When I came to the agency in August 2009, its first of 10 top priorities was to achieve production goals. Early in my tenure, I determined there was an opportunity for organizational changes to both the culture and structure of the agency in several areas, including our anti-fraud and national security programs. I also determined that we must enhance the emphasis on quality in our adjudicative approach. This means that immigration benefit decisions are informed, adhere to the law and the facts, are made in a timely manner, and further the integrity and goals of the immigration system. Within 5 months of my arrival at USCIS, I realigned our agency's organizational structure. I created the Fraud Detection and National Security Directorate, an elevation and expansion from its previous status as an office within a directorate. The resulting prioritization of these core responsibilities has enabled us to achieve unprecedented results. I also created an Office of Performance and Quality to ensure that our agency prioritizes quality throughout its adjudicative practices and mission support processes. As a leader of an agency that administers the immigration laws of the United States, as a former federal prosecutor who has devoted the greatest part of his career to law enforcement, and as a refugee whose blessing of becoming a United States citizen depended on the integrity of our system, it is of paramount importance to me that no USCIS employee, whether because of any perceived pressure to process an immigration benefit quickly or for any other reason, ever adjudicates a case other than in accordance with what the law and the facts warrant. This is an ethic I have articulated and reinforced since I first became the Director of USCIS. Mr. Chairman, Ranking Member Lofgren, and members of the subcommittee, thank you again for the opportunity to share with you the great work we in U.S. Citizenship and Immigration Services have done and continue to do to safeguard our national security and combat fraud. This work allows us to remain the welcoming nation of immigrants we are so proud to be. And finally, I want to again express my deep thanks and appreciation to the men and women of USCIS, who dedicate each and every day to our noble mission and whose hard work and commitment to our principles have made our achievements possible. Thank you.
Thank you, Director Mayorkas. Our next witness, Mr. Edwards.
Good afternoon, Chairman Smith, Chairman Gallagher, Ranking Member Lofgren, and members of the committee. I'm Charles Edwards, Acting Inspector General for the Department of Homeland Security. Thank you for inviting me here today to discuss our report, The Effects of USCIS Adjudication Procedures and Policies on Fraud Detection by Immigration Service Officers. This inspection effort was designed to respond to questions from Senator Grassley after he received whistleblower complaints from USCIS Service Center employees. Our conclusions are based on interviews and survey responses, as well as review of hundreds of email messages, reports, appeal decisions, and media stories. We received input from more than 400 USCIS employees, including Director Mayorkas, and we thank them for their perspective and their collaboration. Our inspection reviewed ways to improve fraud detection in the immigration benefit caseload. In our report, we determined that important steps have been taken to promote the integrity of the immigration benefit system. Nonetheless, additional work is necessary to maximize efficiency and mission performance. It is important to note that several of the problems we identified have been documented for over a decade. Production pressure in the immigration benefit caseload has existed for a long time. Data shows that some benefit denial rates have increased in recent years. Nonetheless, even a benefit that has a relatively high denial rate may still be subject to production pressure. Our report included 11 recommendations for USCIS and a discussion about the standard of proof in immigration benefit determinations. My statement for the record includes further details about all sections of our report. Our first 3 recommendations relate to the interaction between immigration service officers, or ISOs, who process benefit requests, and fraud detection immigration officers, or IOs. Our report recommended that USCIS promote more collaboration between ISOs and IOs. USCIS concurred with these recommendations. Our fourth recommendation pertains to the identification of aliases. Individual aliases or multiple spellings of names complicate the security check process. Because files can be large, ISOs can miss aliases during the review of a case file. We recommended additional quality assurance review to decrease the risks involved in unidentified aliases, and USCIS concurred. Recommendations 5 and 6 discuss further ways to improve ISO performance evaluations. The recently revised ISO performance measures prioritize quality and national security as critical elements. We recommended that USCIS perform on-site outreach efforts to support the new performance criteria and to solicit comments from field staff about the new measures. USCIS concurred. In the remaining parts of the report, we discussed some other pressures ISOs have perceived to approve cases despite doubts they have about their person's eligibility. We recommended that ISOs be given additional time for case processing, and although USCIS did not concur, the issue will be studied further. Several USCIS employees informed us that ISOs have been required to approve specific cases against their judgment. Any such instruction by a supervisor would be contrary to USCIS policy. When it occurs that a higher ranking and probably more experienced supervisor believes the case approval, the supervisor is supposed to sign the decision. An ISO should never sign something when he or she disagrees with the decision, even at the request of a higher ranking officer. Some ISOs may not be aware of this policy, and USCIS concurred with our recommendation that it be enforced. We also recommended that USCIS make improvements to policy on requests for evidence, or RFEs, which are sent if an ISO needs additional information to make a decision. The USCIS Adjudications Manual is unclear, stating both that RFEs should, if possible, be avoided, and that ISOs should request the evidence needed for thorough, correct decision-making. USCIS concurred with our recommendation to clarify RFE policy. USCIS did not concur with the final 2 recommendations in our report, which suggested new policies to define more clearly the procedure to be followed if USCIS managers and attorneys seek to affect the adjudications process. Mr. Chairman, this concludes my prepared remarks, and I'll be happy to answer any questions that you other members may have. Thank you.
Thank you very much, Mr. Edwards. Director Mayorkas, it's my understanding that a few years ago, the Office of Fraud Detection and National Security issued a draft report detailing the amount of fraud in the L visa program. In fact, my staff has been provided with parts of that draft report, which seemed to show many specific cases of L visa fraud. And my staff has also been told that you and other officials at USCIS put pressure on employees to downplay that fraud, and there was belief that if this report were released on the heels of the H-1B fraud assessment, which showed a 21% fraud rate in that program, it would be a blow to the push for comprehensive immigration reform. Even the former head of FDNS indicated that fraud was in double digits, high enough that there should be concern that the agency and department should want to correct it. Director Mayorkas, can you tell us when you plan to release the final report?
Thank you very much, Chairman, for giving me an opportunity to address your concerns. Any suggestion that I downplayed fraud or have ever downplayed fraud is categorically false and is belied by my record since the first day that I started as the Director of U.S. Citizenship and Immigration Services. As I alluded to briefly, when I came into the office, I conducted a top-to-bottom review of the agency, and within 5 months created the Fraud Detection National Security Directorate, elevated its priority within the agency, and have embarked upon and executed a series of initiatives that have demonstrated my prioritization of that critical mission set. I think that the record speaks for itself. To provide some measure of the effectiveness of our anti-fraud efforts, in fiscal year 2011, adjudicators referred over 16,000 suspected fraud cases to Fraud Detection National Security Directorate, and in turn, FDNS, as it is known, completed administrative fraud investigations on 8,739 cases, finding fraud in over 6,000 of those cases, approximately 70%. That is a 34% increase over the number of investigations completed in fiscal year 2010.
Pardon me, Director Mayorkas. I understand how proud you are of your record, and I totally respect that. But with all due respect to the time, that doesn't address the question I asked. And the question I asked simply is, when do you plan to release the final program or report?
One of the initiatives that we embarked upon, Chairman Gallagly, is to improve the benefit fraud and compliance assessment report process. And so what we have done is we have brought expertise to bear to ensure that those reports are prepared in a statistically sound fashion and are well-grounded in fact and study so that we can most effectively direct our operations accordingly. What I have instructed our workforce in the interim is to use the report that it does have, to use the evidence that they do have currently in their possession, and make the operational decisions that they need to. So we are addressing the fraud currently based on the data that we have, and we are improving the report process, including its preparation.
So you do have a draft report that you're using as a basis to proceed ahead. What I would ask then, Director, is can you please provide me by the end of the workday today a copy of that draft benefit fraud and compliance assessment?
Thank you, Mr. Chairman.
Very good. Can you do that?
I certainly can, and whether it's at the end of the day or forthwith, we certainly will.
As long as we have forthwith, I would say by noon tomorrow. Okay?
Very well, Chairman.
Thank you very much. Inspector General Edwards, there's been criticism in the section of your report stating that nearly 25% of the Immigration Service officers who responded to your online survey said they felt pressure to approve questionable applications. Specifically, the criticism suggests that since these ISOs were at USCIS field offices, which do not adjudicate employment-based petitions, so this pressure is not apparent in the service centers where the employment-based visas are adjudicated. I know in addition to the online survey, your investigators also conducted 147 interviews, many of which were adjudicators at the service centers. Did your investigators hear the same kinds of concerns about the pressure to approve questionable applications during the interviews they conducted at the service center with service center personnel?
Thank you, Chairman. Yes, we heard the same concerns during our interviews of the service center personnel.
It's consistent.
Yes, sir.
Very good. Thank you. I see my time has expired. The gentlelady, the ranking member, Ms. Lofgren.
Before I ask my questions, I would like to ask unanimous consent to include in the record a letter from the American Immigration Lawyers Association and also a letter from the U.S. Chamber of Commerce.
Without objection.
I would just note in the letter from the Chamber of Commerce is this statement. Our regulatory economist that reviewed the report, this is for the U.S. Chamber of Commerce, has concluded that the survey methodology should draw into question any reliance on the conclusions in the report. And that is a concern that I have. Now, having said that, and that this is, with all due respect, Mr. Edwards, and it's not personal to you, but I was astounded at the amateurishness of this report. And I expect better, and I'm hoping that maybe we can sit down and talk about the need for statistical analysis for future reports. And I may have some direct questions for you that I'll go into off calendar. But certainly, we don't want fraud. I mean, and I remember being in this chamber a number of years ago in the 90s and pointing out and concern about H-1B approvals. And one Sunday morning, I took the addresses listed in the top 20, and they were all in Silicon Valley. And I drove around, they were post office boxes. And I remember saying, you know, if a middle-aged congresswoman can find out that the employer is a post office box, there was a problem. I mean, this was way before you were here, Mr. Mayorkas. It was in the 90s. And so certainly there's room to improve, and you have made tremendous improvements. I would just note that in terms of just the statistics, if you take a look at the H-1B denial rates, and who knows whether this is the post office boxes I saw back then, but for example, in the year 2004, the denial rate was 11% on H-1Bs. In the year 2011, it's 17. When you take a look at the requests for evidence rates, in 2004 it was 4%. In 2011 it was 26%. I mean, that's a big jump. In the L1B requests for evidence rates, it was 2% in 2004, 63% in 2011. So you're really ramping up the evidentiary standards in the inquiry. And certainly we don't want fraud, but there is a price to pay as well if it's a legitimate effort and it's delayed unduly. And I want to just raise a couple of questions. For example, and this is an actual case, I won't mention the country or the name of the individual out of respect for the process, but it is a former head of state of a Western European nation whose name is a household name, who was applying to come give a speech and was asked to list his employment dates and his employer. It's like, give me a break. I mean, how could that be a reasonable use of our time and effort? And I'm wondering, or for example, a case where the U.S. Chamber has cited where a company wanted to open a fulfillment center in the United States, and there were visa petitions to bring in a handful of foreign staff and to train American staff for the new center. And they couldn't get the visas approved, and so the company went to Canada instead. Or an issue raised by the immigration lawyers of an intercompany manager for a cartridge refill kiosk company that was moving from Spain to the United States. The business took off. They submitted an I-140 for the CEO. It was denied, even though people who reported to him had been approved. And so now the company's looking to move outside of the U.S. I say this not to be critical of you, Mr. Mayorkas, because you are a breath of fresh air for this agency. You've computerized it, you've modernized it, you've rooted out fraud. But what can we do systematically to make sure that our anti-fraud efforts don't tie up legitimate businesses? I worry that if you delay everything, the easy thing to do is to say no. And saying no has a price to our economy, because when you just say no, companies move offshore and Americans lose jobs. I know you care about that. What are your thoughts on that?
Thank you very much, Ranking Member Lofgren. It is, let me first say that one will always be able to present to any large organization an example of a mistake that has been made. But I am immensely and deeply proud of the quality of the work that is performed at U.S. Citizenship and Immigration Services. It's all about quality. It's all about the quality of work that we deliver. And I agree with Chairman Gallagher's statement that there is never a legitimate reason to deny a petition where the beneficiary is eligible for the benefit, and there's never a reason to approve a petition that does not meet the statutory requirements.
I agree with that as well.
And we have focused extensively on improving the quality of our work and providing the tools to adjudicators to perform at the highest level. They have that desire, they have that drive, and they have that commitment to our agency. In the realignment to which I referred in response to the Chairman's first question, I created the Office of Performance and Quality to really shift the focus of our agency from an agency that historically has put a great deal of prioritization on speed to the quality of our work. And the approval or denial rates are not defining. What is important is, are we approving the cases that should be approved? Are we denying the cases that should be denied? And are we providing the adjudicators with the tools to do that?
If I may, Mr. Chairman, it seems to me that sometimes there are informal methods to help improve processes. You know, it's not you, it's the State Department, but I think back to years ago of a case in my office, my constituent, an American citizen, who needed a kidney transplant. And her brother, her younger brother, wanted to donate that kidney. I got a call from the physician, her physician, the surgeon at Stanford, and said she's going to die if we can't get this done in a time frame. Her brother went in to get a visa and was denied. And so we sent an inquiry, please, you know, we've talked to the doctor, the physician called, and they denied it again. And I just wrote to the State Department, this is your decision. But if you kill my constituent, I mean, I think 60 Minutes is going to cover it. And so somebody sometimes needs to look at these things from outside and say, yeah, this is fraud, we don't want to approve it, or we're all human. Mistakes can be made, and to correct them quickly instead of after 2 years is an appropriate thing to do. My time has expired, Mr. Chairman. I yield back.
I thank the gentlelady for being sensitive to the clock. I would now yield to Mr. Gowdy.
Thank you, Mr. Chairman. Thank both of our witnesses. First, Mr. Edwards, this phrase, get to yes, is that a phrase that originated with you? And if so, what evidence did you find to support the notion that there's been a shift in the paradigm and now the objective is to get to yes as opposed to get to correct or get to complete, which would make more sense to me?
Thank you, sir. We don't know who originated that phrase. It is something we came across many times during our field work, during this inspection. But determining who originally said it was not our focus of our review. So I'm not sure who started that.
Well,
I know Director talks about in his testimony about getting to the truth, but this getting to yes, we don't know who originated that.
Getting to the truth would be very hard to disagree with. Getting to yes is a little more subjective, particularly in light of fraud referrals. Let me ask you one other thing before speak to the director. The other phraseology that I found problematic was the notion that outside counsel is running the office, that private immigration attorneys are running the office. What substantiates that allegation? Was it pervasive? Was it episodic? How did that wind up in your report?
Well, there were several cases of this type of improper pressure were brought to our attention. I don't know the exact number in front of me, but I would be happy to provide that to you in writing, or I can come by and brief you.
Well, I would like that. And let me start by saying I listened very intently as you went through your background, particularly as a prosecutor. I have great regard for that. I commend you for the years you served. You mentioned as a federal prosecutor, I don't know whether you're a state or not, but regardless, thank you for your service. You will agree, I'm sure, that if there were an indication that the criminal defense bar were running the DA's office, we would find that very objectionable. And while the reality matters, and I'm not overlooking the reality, the perception matters as well. And if there's a perception within the office that outside counsel has more influence than the reviewers within the office, that's a problem. So did it exist before you got there? What are you doing about it, or is it an unfair accusation?
Thank you very much, Congressman, for your inquiry, because I think you hit on a very important point, that if there's a perception within the agency that is quite divorced from actually what is really happening, we, as leadership in the agency, have to address that, even if that misperception is amongst an incredibly small number of people. I have spoken repeatedly throughout the agency about the fact that there should not be a culture of get to yes, nor should there be a culture of get to no, of which we are also accused, but rather the culture that should prevail from every quarter and across the entire agency is a culture of getting to right, which I think you alluded to. The notion that outside counsel or anyone outside our agency runs our agency is categorically false, of course, and I think what the Inspector General's report reveals to us is that we have to communicate a bit better throughout the agency and amplify the messages that we already have communicated, I in particular, everywhere I go throughout the agency, not only domestically but internationally.
My time's almost up. I want you to harken back to the old days as an AUSA. If you had made a decision and the criminal chief or the civil chief had overruled you because they'd gotten a phone call from defense counsel, you would be appropriately outraged. Did you find any instances where that did happen, where the decision maker was overruled either because an email or a telephone call was placed to a supervisor?
I myself have not, either as a federal prosecutor in the United States Attorney's Office for 12 years or as a director of this agency.
Mr. Edwards, did you find any evidence that outside counsel was able to overturn decisions that were made by line reviewers?
Well, a poorly documented and regulated process to allow some cases to be re-examined in a favorable light is undesirable. It lacks transparency, and lacks internal controls, and creates unfairness. Who you know should not affect the outcome of the process of the petition, but I'm not aware of any myself.
The clock is off, but I don't think that means that you're giving me unlimited time. So
Time of the gentleman has expired, and at this time, the chair would yield to the gentlelady from California, my good friend, Ms. Waters.
Thank you very much, Mr. Chairman. I'm very appreciative for you holding this hearing. I'd like to welcome my witnesses today and say hello to my old friend, Mr. Mayorkas, who served as U.S. Attorney in the LA area, and I got to know him. I'm very pleased that he's here with us today in this very important role. I simply want to get a better explanation of the EB-5 foreign investor visas and try and understand the requirement for investment in high unemployment areas with investments of, I think, $500,000 or so. We've been trying to figure out, for example, in the LA area, we have located all of our regional offices, and we're trying to determine how they define the high unemployment areas getting the benefit of these investments. Could you help me to understand this a little bit better, Mr. Mayorkas?
Thank you, Congresswoman. The EB-5 program is an immigrant investor visa program that provides, in tremendous summary fashion, that a foreign investor who invests the required amount of capital in a new commercial enterprise that creates at least 10 new jobs may obtain conditional lawful permanent resident status. And the amount of investment that must be made is $1 million unless the new commercial enterprise is located in what the legislation describes as a targeted employment area, an area of high unemployment, specifically one that endures 150% of the national average. And the targeted employment area is defined geographically by a state according to the regulations that implement the statute. And then our agency verifies that the geographic boundaries defined by the state as the targeted employment area actually do suffer 150% of the national average of unemployment. That is a very a quick sketch of the program.
Does it work?
The program does work. We can provide data, if you should so request, with respect to the amount of capital that has been invested in the United States and the number of jobs that have been created as a result of the program.
So when you have potential investors, do you suggest places for them to invest? And most of these are like construction projects, I understand. What, are they looking for for places to invest? Do you suggest to them where they can go, where it'd be helpful for dealing with unemployment? How much do you get involved in this?
Congresswoman, we do not encourage investment in a particular project. We do not make recommendations with respect to the advisability of an investment. Rather, it is our responsibility to determine whether the petitions that have been submitted to us do or do not meet the statutory eligibility requirements, and on those, on the facts that are presented to us in adherence to the law that Congress has passed, whether the petition should be approved or denied. That is, if I may, Congresswoman, that is the standard that guides all our work, not just with respect to the EB-5 program.
Are you familiar with this article by Patrick McGeehan and Kirk Semple, dated December 18, 2011, that says, "Rules stretched as green cards go to investors"? Are you familiar with this article?
I am.
And do you agree or disagree with it?
It is not really a question of whether I agree or disagree with it, Congresswoman, respectfully. What the report, I think, sought to identify was what the reporters perceive as a potential for abuse in the regulations that define a targeted employment area, and specifically the ability of states to designate that.
This article talks about the giant Atlantic Yards project in Brooklyn, which abuts the Well Hill Brownstone neighborhoods, that is qualified for special concessions using a gerrymandered high unemployment district. The crescent-shaped zone swings more than 2 miles to the northeast to include poor sections of Crown Heights and Bedford-Stuy. A local blogger and critic of Atlantic Yards, Norman Oder, has referred to the map as Bed-Stuy Boomerang. Are you familiar with that?
I am familiar with the article. I did not study the underlying case about which they reported.
Mr. Mayorkas, have you studied any of the cases that have been identified either in this article or other articles that maintain that the rules are being stretched?
I am familiar with the concerns underlying the reporter's identification of particular cases.
Time of the gentlelady's expired. Before I go to Mr. Goldman, I just briefly want to make a clarification. When I introduced our director as the former U.S. Attorney for the Central District of California, I didn't note that the Central District of California, which is my home, is also the largest district in the nation by population. So that may answer your question, Mr. Gowdy. With that, I'd yield to Mr. Gomer.
Thank you, Mr. Chairman, and appreciate the witnesses being here today. It's rather fortuitous as far as the timing of this hearing, and my friend from California brought up the EB-5 visa issue because I've been finding out more about that just in recent days. Because here's the scenario. Man named Hector Hernandez Javier Villarreal, former Secretary Executive of Tax Administration Service of Coahuila in Mexico, apparently was arrested with his wife, charged with stealing money, embezzling money from Mexican banks. Local law enforcement in East Texas tell me that they were told it could be hundreds of millions, even billions of dollars that were embezzled. Anyway, they were arrested, and folks back home were told they put up $1 million in cash to be bonded out of jail in Mexico, and then applied for an EB-5 visa, which was granted. I'm not sure if there is a policy of get to yes, but certainly yes was gotten to rather quickly with these folks because they needed out of Mexico if they were going to be true fugitives and jump their bond. So they came to East Texas on an EB-5 visa. Local law enforcement and Homeland Security personnel in Texas were told that that actually within 2 or 3 days of the visa being granted, it was revoked. Well, local law enforcement in Tyler, Texas, stopped a car for a traffic violation. They have a good sense on some things just not seeming right. And when they found a car with $67,000 in cash, 2 kids, shotgun, and a driver, they started running these folks and stirred up a lot of interest of ICE as well as Homeland Security. ICE immediately stepped in, wanted to know why they were running the shotgun, which also raises issues. Wonder if this was involved in Fast and Furious. We have no idea. But the federal authorities stepped in. ICE took these folks and materials that were obtained by local law enforcement to the Dallas detention facility. And then Homeland Security reported to the sheriff's office in Tyler, also concerned about the running of the name and the gun. And they were told, well, you have to follow ICE because they've taken these folks to Dallas. Once in Dallas, the law enforcement tells me that the State Department told them they had held them for 48 hours. They got to let them go. That even though the visa was revoked, they got into the country before the visa was revoked. Therefore, they're lawfully in the United States, and therefore, you've got to let them go anywhere they want to go in the United States. So ICE reluctantly, as I was told, released them. And within a day or two, the State Department said, you know what, our neighbor to the south has warrants out on these folks. We really need to get them back. But since they had such large amounts of cash, they've apparently not had trouble going other places as yet undetermined. So that raises all kinds of questions. Are people able to just buy their way into this country by saying, look, you know, we know you've got tough economic times in the U.S., so whether it's $1 million or, as I understood it, these folks were willing to put up $500,000. It must have been perhaps in a high unemployment area. But it sounds like an EB-5 visa is just that, a way for people to buy their way into this country. And why in the world would a State Department direct the release of people for whom there were warrants out in our neighbor country supposedly the State Department wants them to be a law and order country in Mexico. So I'm open to any suggestions as to how we correct this kind of fiasco from happening. And it makes you wonder, do we have terrorists that have utilized this same system to buy their way in? But any suggestions either one of you may have, perhaps we need an IG inspection on this, or an investigation on just what all has gone wrong here. But any comments?
Congressman, thank you. I'm not familiar with the case.
Well, I didn't figure you would be, but if things were as have been revealed to me, as I've conveyed to you, I would like your suggestions on how we fix things the way they are now.
Let me, if I can, given my unfamiliarity with the case that that you describe, make some critical foundational points. Number one, that we as an agency conduct extensive background checks of individuals who seek to enter the United States.
Or you're supposed to.
We do.
Well, it would have turned up a warrant if that had been done here.
As I said, Congressman, I can't speak to the fact
Right.
of that of the case.
So all you can say is you're supposed to do a thorough background
Yes,
check.
indeed.
Right.
Yes, indeed. And we adhere to our responsibilities scrupulously and in a way that makes me quite proud. We've actually expanded the breadth and frequency of the background checks that we conduct during my tenure. You asked a question about the EB-5 program and whether it's really a vehicle for individuals to purchase entry into the United States. The EB-5 program, and I would respectfully submit that it is not. The EB-5 program does not provide, as legislated by Congress, that if you pay $500,000 in a targeted employment area or $1 million outside of one, you shall gain entry into the United States. Rather, that you must invest your capital into a new commercial enterprise that creates jobs for United States workers. It is an immigrant investor visa program that is designed to create jobs for U.S. workers. And so it is not a vehicle for individuals to buy a visa. And so I would welcome the opportunity to speak with you separately. I will learn about the case to which you refer, and I will be in a position to address the facts of the case specifically.
Time of the gentleman has expired.
Mr. Chairman, could I just ask unanimous consent to ask the IG if this is something he would be able and willing to investigate?
Without objection, our day is getting short. We have another panel. We have to be out of here by 4:30.
Congressman, if the chairman makes the request, I'll definitely look into it.
Okay, thank you. Chairman, I know where I need to go after the hearing.
The time of the gentleman has expired. Ms. Jackson-Lee.
Again, let me thank the witnesses for their presentation and as well to acknowledge the chairman and the ranking member for this hearing. First of all, Mr. Edwards, did you find fraud, conspicuous and open fraud in this process that the former U.S. Attorney is over the benefits aspect of immigration? Did you find conspicuous fraud?
No, ma'am.
All right. Wonderful Greek name, I believe. I want to pronounce it right. It is Mr.
It's Mr. Mayorkas, and I come from a long line of bad spellers. It's actually a Spanish name.
Spanish, all right. Then I stand even more corrected. Mr. Mayorkas, let me make sure that that is correct. And the agency that you are over out of the department is a civil agency, right? It doesn't deal with criminal issues.
That is correct. It is an administrative agency.
Okay. And so the idea of this issue of private lawyers running your shop, what does that mean to you? And I'm going to be doing rapid questions. I mean, what do I understand when someone says private lawyers are running the shop?
What it means is that because we are a transparent agency and an agency that engages with all stakeholders, that apparently that transparency has created a misimpression that somehow somebody other than the leadership of the agency runs the agency, and it's a misperception that we will address through robust communication.
Well, let me thank you for that, because first of all, not being administrative and not criminal, or not being a judicial agency per se, the issue of ex parte contact is not an issue. Lawyers have a right to have a conversation. They are civilians. Your workers or employees are civilians as well. And I assume they take information from whoever they might be able to get it from, including advocates for immigrants. Is that not correct? There are some individuals who have an advocate from a nonprofit agency. I assume they have the opportunity to bring information forward on behalf of an immigrant, of someone seeking status. Is that correct? You take information from all.
We take information from all, and we have established channels to receive that information. I think, if I may, Congresswoman, what the chairman was concerned of, and what the Inspector General focused on, and what we are focusing on always, is the fact that there should be no communication that provides an avenue for undue influence on the adjudication, that an adjudication must be independent, based on the facts and the law, and nothing else.
And I agree with that, but as my, and I do not want to put words in her mouth, but as my colleague from California, the ranking member, indicated, where there is life or death matters, we've all made mistakes, and your agency has made mistakes in its denial. And so sometimes people are extremely zealous to save a life, to get someone with a transplant, to get families reunited who were trying to get back for a funeral, and they're in India, and they've been begging for while the person was ailing, then the person dies, and they're denied. So I don't want this hearing to be a statement that you should close your eyes and ears to mercy requests, to information. I have no problem with transparency, and I want the system to be held to the highest standard. So let me just lay that on the record, and let me go forward on these questions. I happen to think there's some value to the employment-based visas. It's my understanding that 10,000 visas a year are set aside for the EB-5 program. However, less than half of these are actually issued. What do you see as the major obstacles for that?
If I may, Congresswoman,
let me just give these questions so it can be on the record. It's my understanding that each immigrant who is accepted under the EB-5, their investment is required to create U.S. jobs. I'd like to know how you monitor that, and I think that responds to Ms. Waters' question as to how do you tie in Bed-Stuy and don't do anything for them. Then under EB-5, what kind of accountability is there for contributing to deficit reduction and job creation? We can use these effectively. And I think they should be used. But go ahead, Mr.
Thank you,
Mayorkas.
Congresswoman. The EB-5 program has enjoyed growth in its usage. Over the last 3 years, we are improving the quality of our adjudications, and we are focused on improving the integrity of the program as well. So while the visa program has been underutilized in terms of the maximum number of visas that are allowed, we've seen material growth in its usage.
Time of the gentlelady's expired. Mr. King.
Thank you, Mr. Chairman. I thank the witnesses for your testimony and your response to the questions from the panel. I'd turn first to Mr. Edwards and ask him, first I want to give you an opening to respond to anything that might have been said that you didn't have the chance to say, but then if you could go into a little more depth on your sense of the analysis of the Get to Yes culture that you've observed exists within the department.
Well, the 400 folks that we interviewed and surveyed, there's extreme pressure for them to get to yes. There are cases that's clearly approvable, and there's cases that's clearly deniable. It's the cases in the gray area that raises the concern. Adjudicators, ISOs, have told my folks that it's easier to say yes or approve it, and if they don't approve it, it comes back to them. So that's what we found.
It's easier to say yes, and because there's a load of paperwork to fill out if you say no.
Because there's a pressure to get things approved.
Mm-hmm. And that be you say it's the culture. Is there a process also? Can I count the extra pieces of paper I have to fill out if I say no as compared to those if I say yes, as it is? as
Yes.
an officer?
Yes.
Is that, did you quantify that in your report, or is that possible to quantify that?
I'll have to get back to you for that.
I would pose that question to you formally in the hearing, ask you to get back on
Sure.
that. If you can quantify how much
Sure.
more paperwork is required to say no than it is to say yes.
Sure.
If it's 91% more, that index exactly with the forms of the highest level of approvals that we have seen. I would thank you, Mr. Edwards, and then turn to Mr. Mayorkas, and I also appreciate your service and your testimony. I just was curious about, as I was listening in on some of the exchanges here, if your department says no to an application, and that might prevent someone from otherwise exercising a privilege, not a right, but a privilege, and that could be extrapolated into the end of life for someone. Could be anything. It could be a plane that crashed, a car wreck, it could be an illness. Would you take that as an action by your department that would have killed someone?
I look at the question as follows. What is the responsibility before us based on the facts that are presented and as we apply the laws that Congress has passed? And if, in fact, an individual applies for a benefit to which he or she is not eligible, under the laws that have been passed, the regulations that implement them, and the facts as presented, then we are to adjudicate the case accordingly. The consequences of an adjudication do not guide the adjudication, but rather the facts and law do.
Then how does that impact you when you hear from this panel, if you kill my constituent?
I don't think that is what Ranking Member Lofgren was asking me, quite frankly.
Can you identify that? I'd like to hear
Would,
that.
would the gentleman yield? Because
I would yield. I'd
think
like to hear
you
this, and I think you should
misunderstood my
have an opportunity
point.
to speak to it. So I would yield to the
Gentleman's
gentlelady from
time.
California.
The point I was making, and I think you probably didn't hear when I said this was the State Department, not USCIS, and it was a constituent of mine who's was dying and needed a kidney transplant, and her brother was willing to donate his
I understood
kidney.
this so far.
They denied his application to come in and donate the kidney.
Yes.
And we had the doctor calling us, we had the hospital, and they just wouldn't listen. And it was their decision, but I finally said, you know, you kill the constituent, there's going to be a dust-up. And when they actually did look at what the doctor said, they issued a visa. The brother came in, he donated the kidney, and then he went home.
Reclaiming my time, and I appreciate the gentlelady reiterating that that was the way I heard it, and it just troubled me, the extrapolation component of that, and I'm hopeful that another statement that the gentlelady made from California, the easy thing to do is say no, doesn't get easier to say no, even if it's the State Department and not USCIS. And so I appreciate the testimony that you've had, Mr. Mayorkas, that it needs to be an objective evaluation of each individual case, separate from statistical data, that on the other cases, it needs to be on the law, and it needs to neither advantage nor disadvantage individuals. It needs to respect and reflect the rule of law. And I think sometimes here we're pushing the line back and forth, but that is the result that we need, yet the data supports something otherwise, and the culture that must exist that has been spoken to by the gentleman, Mr. Edwards. And I'm looking at the chart here of the approvals and the disapproval rate that from 2009 until 2011 that show that the disapproval rating has gone down, the approval rating has gone up, and I haven't heard yet to what you attributed that, and I'd ask if you would let us know what that is. Why does that data show this then?
Congressman, there are categories in which the denial rate has increased, and there are categories in which the denial rate has decreased, and there are times over the stretch of history when one would see an ebb and flow in denial and approval rates. The critical question is, what is the quality of the adjudications that U.S. Citizenship and Immigration Services is issuing? Are we approving cases that should be approved and denying cases that should be denied? Or are we doing otherwise? That is the critical question. It is a matter of quality.
But what do I learn from the data? Can I draw any conclusions from the direction the data has been going over the last couple of years?
Well, let us pose a data point that Chairman Gallagly presented in his opening remarks. The denial rate in the L-1B visa category has increased dramatically over the last 5 years. We can draw from that fact quite a number of conclusions, any of which might be right, any of which might be wrong. The question that I have and the question that I ask internally is not data-driven, but is addressing the substance of the work that we perform.
And can I conclude
Are we
that
getting it, if I may, are we getting it right? Are we requesting evidence when, in fact, further evidence is needed to make a meritorious adjudication? And are our requests for evidence well-framed to further the agency's goals and to be clear to the applicant or petitioner? Are we deciding a case correctly, not worried?
I hear your message, Director, and just in quick conclusion here, then, can I conclude, and would you support an inclination that the quality of the H-1B applications are greater than they have been? That's the trend that we're seeing with the approval rates?
I am not prepared to make that conclusion based on an
Thank you.
Time of the gentleman's expired. For clarification purposes, I'd just like to follow up on the question that was asked of Mr. Edwards regarding the process. Perhaps, Mr. Mayorkas, could you just give us a simple yes or no answer? In the process of adjudicating a yes or a no, if there is a yes or an approval, it merely requires an approve or a stamp yes, whereas if there is a denial, there has to be a detailed explanation for why there is a denial, not just denied versus a rubber stamp yes. Is that fundamentally correct, Mr. Mayorkas?
I think it is fair to say, Chairman, and I know you asked for a monosyllabic response, but I think it is fair to say that there are instances in which to deny a case requires more paperwork.
But the fact remains is it doesn't really require more, from a requirement standpoint, a stamped yes or an explanation for why it's been denied.
There are occasions when that is so, and let me, if I can, say that I am addressing that issue as part of our Office of Performance and Quality.
That part I appreciate, but historically, there is no requirement. I guess the threshold issue is, I guess you can do a lot of things, but there is no requirement to explain anything when you put a yes down, but when you put a denial, there is a requirement for the rationale for the denial. That was my question.
May I?
Sure.
May I have a moment?
It's in the adjudications manual.
It's my understanding that's in the adjudication manual. That's my question.
I will have to, if I may.
Would you check the adjudication manual, and we'll check it, and just for the record, we'll make it a part of the record of the hearing. I thank the panel for being, and I apologize for getting started a little late. Unfortunately, I don't, nor does any member of this committee have much power over when the bells ring around here to go to vote. So thank you very much, and I look forward to getting the responses on those couple issues that we discussed. With that, we'll call up the second panel.
Thank you, Mr. Chairman. Thank you.
Should I call you the Greek now? Introducing our second panel, I would let the witnesses be aware of the fact that their written statements will be entered into the record in their entirety, and request that you keep your opening statement to the requisite 5 minutes. And with that, I'd like to introduce our first witness, Mr. Mark Whetstone. Mr. Whetstone is the president of the American Federation of Government Employees of the National Citizenship and Immigration Services Council. Mr. Whetstone joined the Immigration and Naturalization Service in 1999 and has since held numerous appointments. Throughout his career with the U.S. Citizenship and Immigration Services, Mr. Whetstone has adjudicated thousands of applications for work permits, travel documents, permanent residence, and petitioned for immigrant workers. Our second witness is Mr. Bo Cooper, who is the partner of Barry, Appleman, and Leiden in Washington, D.C., his office where he provides business immigration advice to companies, hospitals, research institutions, schools, and universities. Mr. Cooper served as General Counsel of the Immigration Natural Services from 1999 until February of 2003. Mr. Cooper earned his J.D. from Tulane University Law School and holds a Bachelor of Arts from Tulane University. Welcome to both of you. Mr. Whetstone?
Thank you, Chairman Galilee and Ranking Member Lofgren and members of the subcommittee. I greatly appreciate this opportunity to provide our union's input today at today's hearing. My focus today is specifically on the effects of adjudication, performance expectations, and training levels of the Immigration Services Officer as it relates to benefit fraud in the immigration service system. It's our belief that continuing pressures in the production environment of adjudications, coupled with inadequate levels of training, pose a significant threat to protecting the immigration system from benefit fraud and consequently impacting national security. The recent report by the DHS-OID concerning the effects of adjudication policies on fraud detection correctly points to the need for USCIS to permit more time for our officers' review of case files. This isn't the first time the agency has heard the same recommendation. In May of 2002, the DOJ-OIG suggested the performance standards should be changed to allow more time to review files and seek additional information. In response to this most recent recommendation, USCIS did not concur and seeks to further analyze the need for additional time by adjudicators. There are many things in the most recent report that we can embrace. However, the efforts by USCIS in the area of performance measurement is not one of them. The report would lead you to believe that the production performance measures for all adjudicators were rated non-critical in fiscal year 11. In fact, only 40% of the adjudicator population nationwide realized that adjustment in their performance standards, and even then, the reality was that other critical elements were used to entice officers toward production quotas. The larger segment of adjudicators working in field offices saw no reduction in the quantity-based production standards. Several officers reported working through rest and lunch breaks to reach quota levels necessary to attain just satisfactory ratings. Again, this is nothing new to CIS. In 2002, the GAO reported that because performance appraisal system was based largely on the number of cases processed rather than on the quality of the review, adjudicators are rewarded for the timely handling of petitions rather than careful scrutiny of their merits. Although the recent OIG report states that the decision to make production standards non-critical is a significant change that should improve fraud detection and national security, USCIS has recently moved to change that standard back to a critical element. In reality, production pressure was never off, and this latest action is a reversal of their stated position in the report. In that same report, supervisors and managers noted that adjudicators miss alias names for benefit seekers when conducting security checks during the adjudication process. They go on to assert pressures to adjudicate quickly may hinder an adjudicator's ability to identify and query alias names during the security check process. It's our belief that such issues in this area pose direct hindrance to the detection of immigration benefit fraud. In an August of 2011 report, the DHS-OIG observed that USCIS has not developed a formal post-basic fraud training program. Additionally, fraud prevention training is not provided to all adjudicators responsible for adjudication of specific benefits. We understand USCIS is currently developing post-basic training fraud courses. We also are told that USCIS has agreed to begin the necessary steps to ensure officers receive this training annually once their courses are developed. Although we can applaud any steps towards adequate training for adjudicators, our concern is the frequency of the training will be inadequate. The people perpetrating fraud work hard every day to alter their methods. Providing training to officers only on an annual basis would continue to leave them without sufficient confidence to know when to refer cases of suspected fraud to officers with more expertise and equipped with advanced research capabilities. We believe this is a gaping hole. We know that it's not easy to strike the balance between the efforts to process the volume of requests for immigration benefits while protecting the system from fraud. It is our belief that USCIS policies in this area of production expectations and frequency of training could have a negative effect on the detection of immigration benefit fraud. This concludes my statement. I look forward to answering your questions.
Thank you very much, Mr. Whetstone. Mr. Cooper?
Now? Thanks. Thank you, Chairman Gallagly, Ranking Member Lofgren, and distinguished members of the subcommittee. I really appreciate the opportunity to join in this hearing today. I'd like to focus my remarks on the Inspector General's report. And I'd like to state at the outset that when I was in government, much that we did was made better because of recommendations that were given to us by the Inspector General. They serve a critical role, and much that the USCIS does will be made better by the recommendations in this report. There's a lot in there that will help the agency to become better in its critical responsibility to ferret out fraud in the system and to improve our national security protections. But there are certain aspects of the report that are not in this vein and that, in my view, lack foundation. They're contrary to what happens in the actual adjudications world, and they'd be deeply problematic if they were to inform policy choices. I'd like to focus my testimony on 4 points today. The first is that the Inspector General's conclusions that the USCIS fosters a get-to-yes culture and that it's got an institutional bias in favor of approvals and against requests for additional evidence were made without any evaluation of agency data or any analysis of what the agency's actual adjudication patterns are. Second, the data that surrounds the agency's actual adjudication patterns doesn't support this conclusion, it refutes them. For the key employment-based benefits adjudications, as we've heard today, the rates of denials and RFEs have skyrocketed over the last several years. Third, these actual adjudications patterns have serious real-life consequences that hurt the country's interests. These programs exist to foster economic activity that helps the United States. Careful, responsible employers are having greater and greater difficulty because of these actual adjudications patterns in bringing in talented foreign professionals who could help drive American growth and foster economic recovery. And fourth, any of the report's recommendations that would lead to guidance to simply encourage numerically more RFEs or to raise the standard of proof in a way to prompt more denials would just make this consequence worse. The data indicates that if there's an adjustment trend to be managed at USCIS, certainly in the employment-based adjudications, it's not a trend toward reckless approvals. It's a trend toward more restrictive decision-making in programs that could promote economic growth in the United States. The key issue with the report, with this aspect of the report, again, many elements of it were good. The key issue is that it drew conclusions based on discussions and statements that are important as statements and as indications of what adjudicators feel, but they should have led to more analysis of data. They were conclusions that would lead anyone, and the subcommittee was right to hold this hearing, anyone to think it's a rubber stamping agency that's approving questionable adjudications. But the data don't show this at all. As we've focused on today, the data shows an agency moving in the opposite direction, and the L1B program is the clearest indication. Denial rates have quadrupled since 2008 in the L1B program. RFE rates have skyrocketed so that 2/3 of the matters that are filed in the L1B arena are subject to requests for additional evidence. This is clearly contrary to the notion of a rubber stamping agency that's trying to handcuff its adjudicators in their efforts to reach correct decisions. And the L1B program is, in addition to the starkness of the statistics, it's an important illustration because of the strength with which it illustrates the problems that result from these adjudications patterns. The L1, I think we can all agree that not all brain power in the world exists in the United States. And these programs, these L and H and O programs, exist because of Congress's recognition that it can be in our economic interest to bring these people onto our team in the U.S. It helps American workers. It helps the U.S. economy. These kinds of adjudications patterns are restricting the ability of American employers to do that in ways that could help return job growth and economic strength to this recovery. And therefore, in my view, it was not responsible advice to the agency or to the Congress to draw the conclusions based on the absence of data that were drawn in the Inspector General's report, and that should not be the basis of policymaking in this arena. Thanks, and I'd be glad to respond to any questions that the subcommittee may have.
Thank you very much, Mr. Cooper. Mr. Cooper, your testimony discusses at length the USCIS data showing that denial rates in the L-1B visa category had jumped from 7% in 2007 to 27% in 2011. Looking at the same USCIS data, did you also notice that the overall denial rate for non-immigrant working petitions has fallen over 30% since President Obama took office?
I'm sorry, which category was that, Mr. Gallagher?
That was the all non-immigrant visas.
From my reading of the data and my experience in seeing the process, there's been an increase in denial rates. Now, I think it's important to emphasize that there's not a correct denial rate. There's not a correct approval rate. Adjudicators have to work in every case to figure out what the right application of the facts and the law are and get to the right result. My point is, what I want to emphasize is that with these skyrocketing RFE and denial rates, that should cause us to question very seriously the conclusions that the agency is prodding its adjudicators to rubber stamp questionable applications in a way that's leading to fraud.
On that note, over to Mr. Whetstone. Is it your understanding that the quantity of cases processed will soon once again be officially considered as a critical element of the adjudicator's performance rating?
That's absolutely correct. We received, as the union, we received notice from the agency in September that they intended to move the 40%. In fact, that's all that were really non-critical of the ISOs in the country. Only 40% were placed on a non-critical element. We received notice in September that yes, that they will move. They are moving right now to take the element back to critical.
What are the national security implications of pressure on adjudicators, whether it come from outside immigration attorneys or from USCIS officials or supervisors, to improve immigration benefits?
Well, thank you. I think that the easiest way to say that is the wrong person getting the benefit. If you have pressures being placed on you to move quickly in adjudicating cases, the likelihood of you cutting corners, possibly letting mediocre cases, borderline cases, just flip to yes instead of to a denial, I think that would be the national security implications.
Okay. Mr. Cooper, are you familiar with the July 2008 Administrative Appeals Office decision in the GST case?
Yes, Mr. Chairman, I am.
Are you familiar with the issuance of the Neufeld H-1B memo?
Yes, Mr. Chairman.
Do you agree with that? According to the data provided by USCIS, a rise in denial rates for non-immigrant worker petitions seems to have occurred shortly after the GST decision and around the time of the Neufeld memo issuance?
Yes, I do.
Would you like to maybe just expand that a little bit?
Yes, I would. First, with respect to the Neufeld memo on H-1Bs, that was focused principally, as was noted before, on the employer-employee relationship, and it was addressed mainly at the agency's perceived problems when H-1Bs were being sent to third-party, to client sites, rather than the site of their employer, of the employer. What we've seen in practice is that the rise in H-1B RFE rates and the rise in H-1B denial rates actually affects cases far beyond those that are just third-party placement cases. Likewise, in the GST situation, this in my view is a very serious adjudications issue at the agency, because in my view, the USC takes the position, correctly I think, that GST is a non-precedent decision. But I actually do think that it's very closely tied to the increase in denial rates for L1Bs. My real concern with that case and its effect is that is precisely an example of a situation where, despite the absence of agency policymaking and despite the kinds of interaction with the public that the Administrative Procedures Act would call for example, when there is to be a policy change, this is an adjudications level change toward greater restriction that has brought about severe limitations in the program in ways not that ferret out fraud, but that actually hinder businesses from being able to bring in employees who could help spur economic recovery in the United States.
I see my time has expired. I'd yield to the gentlelady from California, Ms. Lofgren.
Well, first, let me thank both of the witnesses for not only being here today, but their service. Mr. Whetstone, your service in the public, and Mr. Cooper, your many years of service as general counsel. They're appreciated, and the expertise you bring here today is appreciated. I know, looking at the report, 109 individuals said that they didn't have enough time on the interviews. And I am sure that that 109 individuals were sincere in that analysis. However, we've got to have some kind of, I mean, in the private sector, you're going to have some measurement of outcome. I mean, I am assuming, Mr. Whetstone, that you're not suggesting that productivity not be a factor at all in considering how people are doing as employees.
No, not at all, but I think that it should be taken from possibly the individual level to team level or office level.
But if you have one guy who's not doing anything and the rest of the team's knocking themselves out, you should be able to look at the guy who's not performing.
I think that proper motivational efforts by the supervisory staff, and when they recognize that, would be appropriate, yes.
Okay, thank you very much. I just thought it was important to clarify that. Now, Mr. Cooper, you were general counsel when under the Bush administration, just before the current administration. And do you see a difference, now you're in the private sector, do you see a difference in terms of, in your interactions with the agency, that the agency is trying to approve questionable applications?
I don't see at all that the agency is trying to approve questionable applications. In my experience, what the agency is doing is narrowing access to these critical visas.
Now, I'll just lay out. I mean, we don't have really good data at all as to the quality, as Director Mayorkas had said. I mean, what is it? Lies, darn lies, and statistics. I mean, we have some numbers, but you really can't, you know, what we want is quality decisions. We don't want fraudulent applications to be approved, but legitimate applications, we don't want to tie them up because we pay a price in that case as well. I had a concern, just based on anecdotes, that L1s were substituting for H1Bs when we hit the H1B cap. And honestly, I shared that concern with the agency because that would be an improper use of the L1 visa. Are you seeing that the request for evidence is related to ferreting out what of the L1B applications really were more properly H1B individuals?
I do think there's a sentiment among adjudicators that L's are being improperly substituted for H's, and that's driving a lot of their general instinct to be a little bit narrower on L's. I mean, in my view, there's not a situation where a case must be an H or must be an L. They have differing requirements, but there certainly are cases where a person's qualifications and the job qualifications will be overlapped between the two, and in that instance, it seems perfectly appropriate for the employer to be able to choose whichever one the employer would like. And so in that instance, I don't think there's such a thing as really improperly using an L for one that should have been an H. But one point that's very important about you raised the issue of the numbers of filings that are being made. One thing that's very illustrative is that this spike in RFEs request for additional evidence is coming at a time when actually the numbers of L1B petitions that are being presented to USCIS are dropping. And that's inconsistent with the experience that I had in government where when there's a program that seems to have some gap or some loophole that would draw fraud, usually the numbers of petitions go up in that setting.
Can I ask you a question about the sort of the informal appeals process, for lack of a better name? I used some real-life examples in my opening statement where, and you know, we're all human, we can all make a mistake. You read a chart and it's, you know, it says 15,000, but if you read at the top, it's in thousands, so it's actually 15 million. The Inspector General seemed to indicate that if an inspector had made an error and read that as 15,000 instead of 15 million, it would be somehow improper to point that out so it could be corrected, and that the only way to do it would to go to a 2-year appeal process. Isn't that what we're talking about? I mean, if you can't just give some input, oh, by the way, you've denied my client under the Cuban Adjustment Act, but he's not Cuban and he's not applying under the Cuban Adjustment Act, wouldn't that be a helpful thing to a piece of information to give to the adjudicator, not heavy-handed, but here's a mistake?
I think that's important both from the standpoint of those who present petitions and applications to the system and from the standpoint of the agency itself. First, from the standpoint of the user of the system, the person who's making the application. The Inspector General's report seems to suggest, I guess it's premised on the notion that a formal appeal to the Administrative Appeals Office is the only appropriate route to be followed where a petitioner thinks that a decision was mistaken. But it's important to just reemphasize that right now, according to its most recent processing times report, an appeal of an H-1B petition that was denied takes 22 months to be resolved. An appeal of an L-1B petition that was denied takes 23 months to be resolved, almost 2 years. That's a time frame that simply does not work in the business world that's meant to be served by the proper use of these programs. And so that's just not a viable alternative way. That's just not a viable means of addressing problems in today's business world. Second, from the standpoint of the agency, it's in the agency's interest to have situations pointed out to them that they can, if there has been a mistake, that they can correct it in a way that's prompt and that doesn't require the additional resources that get tied up in dealing with an administrative appeal where it's not necessary, and so on. And so in my view, there should be better access for these kinds of situations where people are trying to present the agency with something that they should have another look at, not less. Obviously, if people are you know, calling and saying, can you do me this favor as my pal, or that
would be wrong.
That's entirely inappropriate. But that's not, that is not, in my experience, either inside or outside the prevailing culture within the agency.
My time has expired, Mr. Chairman. Thank you.
Thank you, the gentlelady. Mr. Gowdy?
Thank you, Mr. Chairman. Mr. Whetstone, do you believe that there is a culture of trying to get to yes?
In short answer, no, I don't. I believe that there's some folks that have that perception. I believe that sometimes the way, I'm taking this from folks that I talk to regularly, I believe that they sometimes have that perception. There are some people that do have that perception, but I don't know that there's certainly nothing stated.
Well, perception is important, perhaps only secondary to reality. So let me see if I can venture into reality for a second. It seems as if statistically denials are down, approvals are up, and fraud referrals are down. I don't get out like I used to, but I don't think the human condition has changed that much since 2009. So are we just getting better quality applicants, or how do you explain the statistical discrepancies?
Well, I think that as you laid it out, Congressman, I would say that the pressures to move the workload might have a lot to do with that, and coupled with people or adjudicators' discomfort with the level of training that they have in the area of detecting fraud.
So it's easier to say yes than no?
nobody complains about an approval. They only complain about a denial.
So why did you say no when I first asked you whether there was a culture of get to yes? Because it seems like you described a culture of get to yes.
I don't know that you would call, I don't agree with the term culture of get to yes, I guess, that phrase. I don't think that we have a culture.
How about disproportionate benefits to saying yes as opposed to no? Would you agree with that?
I would say that there are pressures placed on adjudicators to approve cases rather than go through the denial process.
Do you agree or disagree that pressure from outside attorneys can get a denial turned into an approval?
No.
You disagree with the email strings that we have where that, in fact, has happened?
I'm not familiar with those.
Are you aware of any instances where pressure was brought by outside counsel to supervisors and get people to change their mind or else overrule them?
I think on a regular basis, particularly in interview situations in field offices, that you have outside counsel taking issue with how they, if it falls against their client, that they take issue with the way the interview was conducted, et cetera. And I think we see that on a frequent basis in the field offices. In the service centers, it's probably less frequent, but I've known of instances where an AILA attorney or someone would make complaint about some decision that they received, and it would get reworked, if you will, and the officer is left with the impression that it was the outside influences that caused that decision to go another way.
Well, if we agree on the number that fraud referrals are down 22%, and if we exclude the option that the human condition has improved dramatically since 2009, what other explanation would there be for a reduction in fraud referrals?
Well, I think that that officers might, like I said before, their training level, they probably don't have the confidence to actually refer. I think that we've had reports from individuals saying that their supervisors discourage referrals to the fraud detection officers.
Are you aware of any retaliation? I think Chairman Gallagher began this by making reference to Senator Grassley, who was approached by whistleblowers. Are you aware of any retaliation against the whistleblowers or any complaints of retaliation?
I'm aware of the complaints by those whistleblowers, but as far as retaliation, I can't say that I am aware of that, no.
But those complaints have not been adjudicated yet? Or if they have been,
I've really lost track of that case. I don't know.
I think it'd be cases, plural.
There is two there, I think.
I would yield back the balance of my time, Mr. Chairman.
Thank the gentleman. Mr. King.
Thank you, Mr. Chair, and I thank the witnesses. I just start first with Mr. Cooper, and I recall your testimony you addressed earlier that data refutes the claims of the previous witnesses and some of the reports that you've seen before this committee today, and you pointed to the L1B program as the example of the data that refutes the claim. Could you point to another program, another visa that also refutes the claim?
The L1B is the sharpest example numerically, but certainly across the employment-based programs, the trend is just the same. With H1Bs,
But if we went, excuse me, if we went, I'll just say the Obama administration, 2009 to 2011. And I look at that data, that's the most recent trend we have under current administration. So do you have any other visa categories other than L1B that would support your position with regard to the data demonstrating the opposite of the balance of the testimony here, other than your own?
Sure. Well, in the H-1B program, of course, it went, if you go back to 07, it went from 11% to 29% in 2009. And it has subsided since that 29% rate, but it's still much higher than it had been in, say, 2007.
We know that there's been some reforms that took place that tightened down the regulations. I think you answered that response. It was to the question of Mr. Gallagher on that. So I just look at the rest of the data, and I just make the point, and I have looked at the last 2 years, and I can find another example that supports your position. It's marginal as can be, but it's L1A. And 2009 till 2011, in that gap that I'm addressing, it went from 13% to 14% denial rate. So it's, you know, statistically at the level, but the balance of this shows the opposite in the data that I'm looking at. And I just ask in your leisure time if you could review the data for the 2009 through 2011, which would be the most pertinent data we have for the current administration. And not to beat that point, I just recognize your point, and but it appears to be an exception on the current information, current administration information. Another question is, listening and thinking about what the IG's testimony was, if it does come down to who you know, and may or may not, I'm listening to Mr. Gowdy's exchange also with Mr. Whetstone, and you may or may not know that either, whether it comes down to who you know, depending on where you sit and what you hear. But if the IG went in and did a thorough examination and came back with a report, and if it was an issue of who you know, how would he know that it was who you know, and how could you quantify that? Can you imagine any way that the IG could actually conduct an investigation to come to a conclusion that there's data points along the way that would bring it back to it being influenced by who you know?
Yeah, I think the data points would actually be quite scant because the fact is that there's no real formal way to reach into the agency that's effective other than the actual filing of the petition and the paper responses when they ask you for more information. And so it's not surprising that sort of impression emerges from the commentary of the people who were interviewed and those who responded to the district level online survey. And you know, I think it is important to note that this sort of sentiment does exist in the agency. It certainly did when I was there. And it's not that the sentiment is unimportant. It's very important to have structures where you get buy-in from your adjudications personnel, structures where you can make a policy and have them and have your adjudicative personnel abide by it substantively and so on. So I'm certainly not disputing that sentiment exists.
Well, would Mr. Cooper, would we agree that even when the sentiment exists, it may or may not be based on fact, and that in the end it's going to be a subjective opinion from wherever you sit? If you're an inspector, if you're an IG investigator, if you're an attorney that's an advocate, you're going to have a different perspective on how much influence might change this. But would we agree that immigration attorneys do attempt to influence in that fashion?
Oh, it's certainly the case that attorneys try to bring to agencies attention when they think that there's been a mistake, a substantive mistake in the adjudication. That certainly happens, and it should happen more often in my view.
But I mean, we're not presuming that a well-positioned attorney wouldn't drop a name here and there when they're discussing this with the inspectors, with the investigators.
I'm not making an assumption one way or the other on that. I can agree.
But I mean, we are people of the world here, and we couldn't possibly assume that doesn't happen. I don't think we need to examine that any further. I just make the point that it is subjective. People do try to influence with who they know. Whether it gets through or not is another question, and if it does get through, there's no way to quantify. And would you agree with that, Mr. Cooper?
I would agree with that. It's subjective. In my view, it's not at all the case that the agency is owned by outside counsel.
And watching my clock turn here, do you think it'd be proper? That it's proper for immigration attorneys to have direct access to USCIS supervisors?
I think that if there were regular access, the system would probably work better.
If you think there were regular access from immigration attorneys to the USCIS supervisors?
Not necessarily supervisors, but to the system. You know, as of right now, there's an appeal, there is the 800 number for the customer service number, and there's the paper filing, and none of those is an effective way of having an efficient exchange of the information.
You may advocate for an open dialogue, but then if there's direct access to supervisor, wouldn't that also mean taking it up the chain and trying to apply the leverage and the influence?
Yeah, I'm not talking about leveraging influence with supervisors. I'm just saying that if there were a better way for the agency to have access to information and arguments that could help it understand when it may have made a mistake, and I know this from experience inside the government, that can help you to avoid unnecessary litigation, it can help you to avoid unnecessary administrative appeals costs, and it can lead to a lot of benefits for both sides.
So you're speaking objectively and procedurally rather than from the personal influence?
I'm speaking from my experience on the inside the government and my observations since.
Thank you, Mr. Cooper. Mr. Westone, I'm sorry I didn't have time to get to you, but I'm sure you're the reason for the sharpest knives in the drawer. So I appreciate you coming here to testify and the service you have, and I yield back the balance of my time.
I thank the gentleman. And
Mr. Chairman?
yes.
May I ask unanimous consent to include in the record the denial rates showing a massive increase in denials between the Bush administration and the Obama administration?
Without objection. And I would ask unanimous consent to enter into the record a statement from the Senate Judiciary Committee Ranking Member Charles Grassley noting that the get to yes culture is a direct contradiction to our one priority of protecting the homeland, and that undue pressure on adjudicators must be dealt with in order to ensure integrity and root out fraud in the immigration system. Number two, the statement of John Lynch, a U.S. CIS adjudicator in the San Diego field office, whose personal experience validate the OIG findings that there is pressure of adjudicators to approve applications despite inadequate processing time or fraud indicators. And number three, an email chain between the U.S. CIS officials stating that U.S. CIS wants to get to the point where the cases denied are those that couldn't possibly be approved under the law. With that, I want to thank without objection, hearing no objection, those requests will be added to the record of the hearing. I want to thank our two witnesses and, in fact, all of our witnesses. I think that this has been a productive hearing. And without objection, all members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which will be forwarded, and ask that the witnesses to respond as promptly as they can, so as the answers will be made a part of the record of the hearing. And without objection, all members have 5 legislative days to submit any additional materials for inclusion in the record. Again, I want to thank the witnesses and thank the members of the committee. And with that, the subcommittee stands adjourned. My personal favorite is RFE on the 140 from Nebraska Service Center asking Microsoft for their financial statement. Really? I think they can make it. But you know, they've lowered the standards.
just get, why do we have to have numbers at all, was the first question. And I said, well, you know, if it's in our culture, all right, we've always done numbers. He says, well, you know, I believe that we just make the quality, we give the teams an emphasis, the goals, and then you make those managers goals, and you encourage your employees to actually we've been hiring technicians, not supervisors. It's time for them to hire supervisors. I remember her regional director, so she remember that one?
I stayed around. Everybody else left. I didn't. Once I saw everybody left, I had to stay. But by the way, the difference is if Bo Cooper has a case going into CIS, and Sheldon Zelli has a case going into CIS, you're going to get a lot better. They will respect your because you're a better trainer. There's a difference between you and your attorney, you guys clients. That's pragmatic. They're never going to get, and that's the nature of the system. It's not pressure. It's not a pressure of an adjudicator to pressure to get an approval. That doesn't work. It backfires on you all the time. Right. You have to present a case that's approvable. But it's all in the discretion. But if I'm an adjudicator and I get your case, I say, Cooper's right. You know, it occurs to me if these cases exist. There is just, that's what you earned it. That's just the reality of it. I mean, but it's true. You do that stuff. It's good to see things.
I've been on that for years, watching this go. You know, they couldn't do it December 16th for a reason. And now sanitize.
Oh, this is my friend. My colleague. She's the brains in our office.
Here all the time. On the team. And I said, you're septic testing.
Did I answer?
Right? So they went in there and ready to pull the trigger. He pushed one button, technical guy. He pushed one button, right? He was able to look at everybody else's, all these other aliens, birth certificates, any kind of birth certificate, wet marriage certificates, and he goes, everybody says that they were about to, is the problem.
How do I get in? I was surprised that boom, boom, boom. It's it's each one.
Yeah, it's surprising.
And they don't like turns either. This guy doesn't like turns. He doesn't like turns. This is like doing this. I mean, from my perspective,
He's ready to fight.
okay, thanks, David. See you later.
He's getting
Bad decision. It's not all that. It's not all that gold and glitter. A lot of people get really unhappy. And when they get the condition that's been under control. Right. A lot of people look at me.
All we need to do is get we're sitting around and put things back in, way, we may as well type writers.
Nice to see you.
It's dumb.
Thank you so much.
Thanks very much. And I spoke with him.
This is that guy, Grievous.
Throw it in. Yeah.
What's that?
You hear them calling down here? Grassley
Yes.
letter? No, how do you think it went?
Yeah, I mean, you got the point. I know one guy had a little hard on it seemed from South Carolina.
Oh, very neat.
This culture of yes thing, it's always.
All that was is that
But that term, yeah, I've never heard that term though before. Yeah, they're more apt to grant.
He was advocating for Chris Poulos and Brett Gregg, and that's why he said more than one. I said, yeah, two. But I should have said something about, yeah, but the second one hit a couple judges on the way out with a DUI.
Well, yeah, you don't want to.
Didn't want to bring that part up? No,
Well,
on the record.
It's not something for later.
Yeah, but he wanted a piece of it for some reason.
Yeah, I don't understand. But yeah, everything went well. I mean,
The whole he's looking over at what you're at. Because that's the whole thing that was. Let's go out this way.
yeah.
Gotta push my chair in, otherwise it won't bite me back.
Walk into my office if you want. I'll put the, there's a lot. There's RFP data. There's, I know. I should have shared with you earlier, actually. It's in Excel. There's a, yeah. I mean, there's more data out there that I don't. It's different kinds of data, different press has different data than we do.
Send it to you and she print out a copy and hand it to her. She can read it.